Hi, my name's Isaac Shutt. I'm an estate planning and probate and trust attorney. I'm licensed both in Texas and in Wyoming. And I'm going to answer a question today that comes into my office pretty frequently, and that is, should I put my kid's name on my assets? This comes about in kind of two different ways. Usually people come in and they say, you know what, I don't need a will or a trust or anything like that because I've already handled that. And I'm curious, what do you mean you've already handled that? And they go on to say that they've added their kids' names to the deed to their home. The other way that people come in and talk with us about not needing a will, a trust, or things like that is because they say, I've already added my kids to my bank accounts. So I'd like to talk with you about each one of those things and really to answer the question, should you put your kids' names on your assets during your lifetime? Let's start with the real estate. Well, what happens is people come in and they say, I've added my daughter Janet to the deed to my home. I've heard all kinds of terrible things about how terrible probate is and how the nursing home is going to end up with all my assets. So I'm going to outsmart everyone and I'm just going to deed it over to my daughter Janet now. And is that a good idea? Well, I can tell you generally no. It can be fairly disastrous, in fact. And there's kind of two reasons why. One is that it's typically not very tax efficient to add your daughter Janet to the deed to your home. And number two, there are some creditor exposure issues here that maybe you hadn't thought of. Okay, so let's talk first about maybe some tax downsides to putting your kid's name on the asset of your homestead during your lifetime. Well, here in Texas, we have some pretty steep property taxes, and that's mostly because we don't have a state income tax, and so the way our government kind of raises money is largely through property taxes. And what that means is that particularly on your homestead, the homestead exemption and over 65 exemption and veterans exemptions are all vitally important. If you were to lose your homestead property tax exemption, or if the case is applicable, over 65 or veterans exemptions, that is a big chunk of money that you are going to pay extra every single year. I mean, thousands of dollars every year in taxes that you're going to have to pay if you lose those exemptions. So you're not going to be eligible for an over 65 exemption if you deeded the house out of your name. In other words, if you deed the house to your kiddo, it doesn't matter that you reside there, you're no longer the property owner. And so you have to be both the property owner and the person who makes it their primary residence in order to qualify for all those tax exemptions. So what happens is when these people come in and they think they've very smartly deeded their house to their kid, they get their tax bill the next year and it is oftentimes double what it used to be because with an over 65 person, your property taxes are frozen. And so if those taxes get unfrozen, now your property tax jumps to the current rates, and that's a big difference potentially from what that person been paying. So again, property tax wise, there's a big problem with deeding that house over to Janet now. Another thing is capital gains tax. So another tax related problem to putting Janet's name on that house is it actually would have been better tax wise for Janet had she inherited the property or received the property as a result of your death. So what I mean by that is, let's just use an example. Let's say you bought your home for like $100,000 in North Dallas in like the late 60s. And let's say you've resided in that house for all these years and now that house is valued at $1.1 million. Okay, well great. The house has really gone up in value. That'll be very nice for Janet to inherit when you pass away. But there's a capital gains tax, which is a tax that we pay when we sell real estate that is basically on the difference between the original purchase price, which we call the basis, and the sales price. So on that gain, you pay a tax called the capital gains tax. So the difference between $1.1 million and $100,000. So if you deed that property to Janet now, she gets your basis, which is $100,000, which means if she sells it after you pass away, now she's got to pay a tax on the difference between $100,000 and whatever crazy amount she sells it for after you pass away. However, had she gotten it through a will or a trust or something like that, under current law, she would get a stepped up basis, which means take the date of death value of that home. Let's call it $1.1 million. Let's say she sells it for $1.1 million after you pass away. Well, then she would pay no capital gains tax. So again, inheriting the property either through a will or a trust a lot of times is very tax beneficial for the person who's receiving that property, and that benefit would be lost if you had deeded it over before the death. So how can you avoid this? If you just really are not comfortable with the idea of your house going through probate, there are some other methods. So first of all, I want to say that having your house flow through your will in the probate process in Texas is really not terrible. You hear a lot of talking heads on the news and on the interwebs talking about how terrible probate is. And in some states that may be the case, but in Texas it's not terrible. So kind of the normal thing to do, like putting your house in your will and letting Janet inherit your house through the will and the probate process upon your death, is really kind of great. It's not terrible. But you could, if you wanted to go the extra mile, you could set up a trust. And a lot of our clients have a will that gives everything to their revocable living trust. But you can also sign a deed into the trust during your lifetime. And so when you passed away, that house was actually not in your name. It was in the name of your trust. And by doing that, you do preserve your over 65 and homestead exemptions, but also probate is avoided since that asset was no longer in your name, it was in your trust name. And just by the terms of that trust document, Janet would automatically inherit that house. So you could deed the house into a trust and let her, Janet, inherit the house through the trust, which would be great. There are also a couple of deed options that in a more tax efficient way give away that property upon your death. One is called a ladybird deed, which is a nickname for a life estate deed, or enhanced life estate deed rather. And so that's a great type of deed that a lot of our clients take advantage of. There are some pros and cons with that I don't have enough time in this video to discuss, but you should definitely talk with an estate planning attorney about a ladybird deed. And there's also something called a transfer on death deed. And again, pros and cons to doing the transfer on death deed, but it might be something of interest to you as well. So those would be other things to ask a lawyer about. And so I think it's important just to be thoughtful about this, and instead of just going online and getting some sort of, template deed to give your house to your kids, I think you should be really thoughtful about the tax downsides to that. I should also mention that there may be also some liability concerns. Here in Texas, homestead properties have some special protections, meaning if you get sued, your homestead property is kind of hard for the outside world to touch. So, even if you lose in a lawsuit or, have a bunch of bills or things like that, it's relatively difficult for that outside world to collect your house. That's pretty safe. Your house is pretty safe. But once it's no longer your homestead, it loses that protection. And even scarier, let's say you deed the house to your daughter, Janet, and then Janet gets in a lawsuit. Well, now your house is potentially exposed to liability for Janet's lawsuit. And I don't know about you, but a lot of our clients would be very uncomfortable with potentially losing their homestead to a lawsuit. And so they would want to keep the house in their name to make sure they keep that homestead liability protection, which is very strong in Texas. Okay, so we've talked enough about the real estate and whether or not it's a good idea to transfer that asset to the kid's name during your lifetime, but let's talk about the other really common one, which is the bank accounts. A lot of times we have clients who come into our office and say, you know what, Isaac, I don't need a will or trust or whatever. I've already taken care of that because everything I have is in my bank accounts. And I already added Janet to my bank accounts. I already added my daughter to my bank accounts, and she'll take care of everything. Okay, and you know what? This is actually, sometimes people have actually done this accidentally. In other words, if you walk into a bank right now and say, "Hi, dear banker, I would like to add my daughter Janet to my bank account," they will just say, "Oh, yes, ma'am," and click a button on their computer and say, "It's all taken care of. Janet is on the account now." And sometimes what the client had intended was basically just to add daughter Janet as basically a convenience signer, meaning like somebody who would be able to access your accounts for your benefit to help you with taxes or bills or things like that. And so it wasn't really intended that you give the account to her, at least not at that moment. The intent was really just as a convenience to you to be able to access that account to help you with bill paying and things like that as you grow older. And so the bank, without even discussing the matter with you, will just add her as a joint tenant with rights of survivorship. And so if you say, "I want to add Janet to my account," without any pomp and circumstance, they're just going to add her as a JTROS, joint tenant with rights of survivorship. So you'll see it abbreviated sometimes as JTROS, other times as JT10 or JTWROS. But let's talk about what that really means and why you wouldn't want to have accidentally added Janet as JTROS. Well, JTROS means that Janet now owns that account just as much as you do. I mean, that's a little crazy. You should be a little scared by that, because basically what that's going to mean is that if she gets sued again, potentially your account is up for grabs. Maybe she is having a marriage that is having problems. Maybe your account is now exposed because there is some income, and maybe her soon-to-be ex-spouse would complain that there's some community property in really what's your account. And so there are a lot of problems with that. And one of the frequent problems that we see with JTROS designations is that, the client actually has, let's say, 3 children, and Janet is just one of the 3 children. And I have a problem with that for a couple of reasons. Number one is I have dealt with Janet's after, the death of the parents, and I wouldn't take it as a guarantee that Janet will divide that account evenly with her siblings. A lot of times, Janet will start saying, "You know what, after mom and dad had died, they really meant for me to have it. That's why they only put my name on it." And I know it's hard to imagine that your kid would ever do that, but trust me, it happens. And so I follow the better safe than sorry approach and don't even allow that to be an option for Janet. So, if she is the joint tenant with right of survivorship and you pass away, legally, it's her account. Whether or not Janet decides to split that with her siblings is legally her choice. She's not obligated to split the money with anybody else. Legally, it was hers. And so that kind of leads to the second problem with Janet being the JTROS on your bank accounts, which is even if she does choose to do the right thing and split the money evenly with her kids, well, guess what? The tax man viewed that as Janet's money. So if Janet gives away, let's say, hundreds of thousands of dollars from that account to have it evenly split with the siblings, well, the tax man is going to look at that as a gift from Janet, not from you, because legally, in the eyes of the law, it was Janet's, and so her making the decision to split it with the siblings would be taxable as a gift to her. So she's going to have to report a gift to the IRS in her own name, and for most of our clients, that wasn't the intent, to make life more difficult for Janet with tax reporting and potentially having to pay some tax. I know that wasn't your intent by adding her to the account. So other ways around that, again, have a will, have a trust. Those are great ways to go, and you should do that. But also you can talk with your bank about, instead of adding Janet as a JTROS, which the bank almost bullies you into, stand up for yourself and say, "No, I only want her as a convenience signer. I only want her as a convenience signer. I want her to be able to write checks for me, but it's still legally my money. So she can handle things for me, but it's still mine. And that's called convenience signer. Another thing you can do is have an estate planning attorney like, an attorney like us to prepare a power of attorney or medical power of attorney and all those kinds of things. We typically do those as a bundle. But that durable general power of attorney would give Janet access to your accounts. So that's really the safest way to go, because with that power of attorney document, she's undertaken a duty to work for you. So you have some legal assurance that your account will be handled for your benefit using that power of attorney. And then you don't have any of the problems post-death of, hey, this is a taxable gift from Janet, because it was never put into Janet's name like with the JTROS. So the power of attorney would really be a lot safer than the JTRS for you and for the other kiddos, and also probably save some taxes potentially as well. So with all that, I think the moral of the story here is, sometimes you've heard the saying that an ounce of prevention is worth a pound of cure. If you had talked to an estate planning attorney even for a few minutes, a lot of these things would have been ferreted out and discussed. And so this is, relatively normal stuff for an estate planning attorney to deal with, and could have really helped save your family a lot of hassle and legal expense and maybe some tax problems. That could have all been easily avoided with a short conversation with a lawyer. And so I think it's a good idea to have a lawyer for this sort of counsel, to talk about these sort of things. It's not just about whether or not that deed that you have is legally correct. It may be legally correct, but the question is, was that deed the right deed in the first place? And so that's why it's important to actually have counsel and to have advice. So I strongly advise you to consider having a lawyer, to have sort of that one-on-one, because your fact pattern might be different than your neighbors or your friends or whatever else, and what might have been best for them may not have been best for you. So you should probably have your own attorney to help you look out for these things. And of course, we'd be happy to hear from you. Again, my name's Isaac Shutt. I'm an estate planning attorney licensed both in Texas and in Wyoming.